आताचे आपले तज्ञ मार्गदर्शक म्हणून आपल्याला लाभलेले आहेत आदरणीय ॲडव्होकेट श्री श्रीकांत कानेटकर सर. श्रीकांत कानेटकर सरांचं आगमन आपल्या व्यासपीठावर झालेलं आहे. तत्पूर्वी त्यांना तुमचा परिचय मी थोडक्यात करून देते. आदरणीय ॲडव्होकेट श्री श्रीकांत कानेटकर सरांचा जन्म 24 मे 1949 मध्ये झाला. सरांनी अर्थशास्त्र या विषयात BA ची पदवी संपादन केली. तसेच सरांनी फर्ग्युसन कॉलेज पुणे येथून LLB ची प्रथम श्रेणीत पदवी संपादन केली. तसेच 1982 ते 2009 या कार्यकाळात त्यांनी याच कॉलेजमध्ये प्राध्यापक म्हणून सुद्धा कार्य केलं. तसेच सन 1998 ते 2003 मध्ये सरांनी बार काउन्सिल ऑफ महाराष्ट्र गोवाचे सदस्य म्हणूनही कार्य केलं. तसेच सन 2000 मध्ये सरांनी बार काउन्सिल ऑफ महाराष्ट्र आणि गोवाचे अध्यक्ष या पदावर सुद्धा कार्य केलं. आणि सर दिवंगत मुख्यमंत्री विलासराव देशमुख यांचे वकील म्हणूनही यांनी वकिली क्षेत्रात कार्य केलेलं आहे. सर मुख्यतः सिव्हिल, कोऑपरेटिव्ह व्होट, इलेक्शन मॅटर्स, कॉपीराइट मॅटर्स, ट्रेडमार्क मॅटर्स या संदर्भात वकिली क्षेत्रात कार्यरत आहेत. सरांनी विविध अशा निवडणूक दाव्यासंदर्भात मुंबई व औरंगाबाद उच्च न्यायालय येथे कार्य केलेलं आहे आणि सध्या सर पुणे येथे जिल्हा न्यायालयात वकील म्हणून कार्यरत आहेत. तसेच सरांनी ILS लॉ कॉलेज पुणे येथे अनेक वर्ष पार्ट टाइम प्रोफेसरशिप म्हणूनही कार्य केलेलं आहे. आणि मित्र हो, आपणा सर्वांना सरांबद्दल एक कौतुकाची आणि अभिमानाची गोष्ट सांगू इच्छिते. ती म्हणजे अशी की बार काउन्सिल ऑफ महाराष्ट्र आणि गोवातर्फे आयोजित जे JMFC क्लासेसचे प्रशिक्षण नागपूर येथे आयोजित करण्यात आले होते त्या संदर्भात सरांना एक तज्ञ मार्गदर्शक म्हणून बोलविण्यात आलं होतं. आणि त्या मार्गदर्शनात सरांनी सतत 6 तास शिकवून आम्हाला एक नवीन मार्गदर्शकाची एक दिशा दाखवली आहे. आणि इतक्या व्यस्त कार्यकाळातून सुद्धा सर अगदी सकाळी पुण्यावरून येऊन आम्हाला कंटिन्युअस न थांबता कुठल्याही पुस्तकाचा आधार न घेता आम्हाला CPC हा सब्जेक्ट अतिशय सोप्या आणि उत्तम भाषेत सरांनी आम्हाला शिकवला. म्हणूनच मित्र हो, बार काउन्सिल महाराष्ट्र आणि गोवाचे जेही कार्यक्रम इथे आयोजित होत असतात तिथे सर आवर्जून उपस्थित राहत असतात. अशा सरांचं स्वागत तर नक्कीच व्हायला हवं. म्हणूनच मी आदरणीय ॲडव्होकेट श्री कानेटकरांचं स्वागत बार काउन्सिल ऑफ महाराष्ट्र आणि गोवाचे उपाध्यक्ष ॲडव्होकेट अनिल गोवर्तीपे सरांनी पुष्पगुच्छ व सन्मान चिन्ह देऊन करावं अशी मी त्यांना विनंती करते. मेघ भरून येतात आतुरतेने धरतीला, आमचे मन धावते तज्ञांच्या मार्गदर्शनाला. म्हणूनच आजच्या या सत्राचे तज्ञ मार्गदर्शक सर आदरणीय ॲडव्होकेट श्री श्रीकांत कानेटकर सरांनी लॉ रिलेटिंग टू इंजंक्शन या विषयावर मार्गदर्शन करावं अशी मी त्यांना विनंती करते.
Friends, the Vice Chairman of the Bar Council, Gowardipe, Member of the Bar Council, Jadhav, all other members and my friends. The subject that has been given to me today is law relating to injunction. Friends, those who are practicing at civil side must be aware these provisions of regarding law relating to injunction. Every day, every hour, every minute you are required to take into consideration what is this concept of an injunction. Hardly there is any litigation where you are not required to make an application for injunction. Everywhere, and that is we talk about Exhibit 5. But Exhibit 5, that is a temporary injunction, is altogether different aspect. We will tell it is one of the concept. We have to first understand what is mean by injunction, how many types of injunction, and one of the injunction is a temporary injunction. Friends, we know that well, we file a suit for partition, we file a suit for specific performance, we file a suit for this particular recovery of money. Everywhere we say that well, we make certain reliefs. But if you find the provisions of the injunction, even suit can be also simpliciter for injunction. When I will explain to you that well, for example, if you file a suit for permanent injunction, if plaintiff comes with the case saying that I am already having a title, I am already in possession, but my possession is being disturbed by the defendant without following a due process of law. He need not ask for a declaration, he need not file a suit for any other purpose. he can simpliciter file a permanent injunction. So what is this concept of an injunction? Injunction is like any other like particular relief, a judicial remedy. A judicial remedy by which one can file even a suit for permanent injunction in the nature of specific performance. Let me give an example to you. For example, if it is a case that a builder enters into a promoting builder enters into a agreement with the flat purchaser, thereby agreeing to give possession of a particular flat after completion of that particular flat within a particular period. Now there is an agreement, there is a contract by which builder for consideration agrees to give a flat within a particular time limit. If he does not perform, and if he tries to give the possession to somebody else, a flat holder simply can file a suit for permanent injunction. That is in the nature of specific relief. Don't be under impression that specific relief means always that it may kindly be declared that the defendant should execute a sale deed, etc., etc. When we talk about a permanent injunction can be molded in the form of a specific relief. That means by asking, ultimately what is meant by permanent injunction, when I am going to explain to you that to prevent the breach of the contract. If ultimately you file a suit saying that that the defendant may kindly be permanently restrained from committing an encroachment over my property, or the defendant may kindly be restrained from handing over the possession of that flat to me except to the plaintiff. In a sense, you are asking a performance of the contractual obligation in the nature of permanent injunction. Therefore, we always say the injunction. I am not talking about just now permanent injunction. We'll see what are the types of the injunction. The injunction is nothing but a judicial remedy which can be kept in the service by any particular plaintiff. Now, in what circumstance injunction is to be granted, etc., we are going to consider it in that case. Friends, therefore, when we say it is a judicial remedy, where in the form of by which the order can be passed by the court in the nature of directing the particular person, that is not to do something or to do something. Injunction is, we consider that not to do something, for example, not to take possession without following a due process of law, or to do something, construct the wall which we have demolished, that is defendant has wrongfully demolished. So injunction may be in the nature of ordering the defendant to do something or not to do something. That is what we say, therefore, for the enforcement of rights, etc., etc., obligation. So this is the general concept of an injunction, to do something or not to do something. Now when we say, therefore, how many types of injunction? When we say that injunction not to do something, that is we call as prohibitory injunction. The concept is a prohibitory injunction. For example, when the plaintiff himself is in possession, he has got a title in respect of the property. He says that defendant may kindly be restrained from taking the forcible possession without following a due process of law. He is asking the injunction against the defendant not to do something. That is what we saw, prohibitory order. But take an example. Landlord, in order to harass and so that the tenant should vacate the premises, suppose remove the roof. Only 4 walls remains. Whether can we say the remedy of the tenant has gone? No. He can come in the court of law and say, direct the defendant to erect that roof. Or if he demolish one of the wall, he says that direct the defendant to construct that particular wall. Means what? He is asking the particular prayer to do something. It is nearer to the concept of mandamus, what we talk about in the High Court. If you have seen 5 types of writ petitions, writ of mandamus, you must have seen the public interest litigation. You must have read it, you must have heard about it. So it is in the nature of mandamus, in a sense, the plaintiff asks a particular making a prayer to the dependent that compel the dependent or direct the dependent to do something. So therefore, how many types of injunction? Initially, prohibitory injunction, that is prohibitory order, and second is mandatory injunction. But if we see the prohibitory injunction and again mandatory injunction, these are the main two types of injunction. But if we see further, then we'll further consider that further types of injunction. In case of a prohibitory injunction, there are two types of injunction. That is, one is a permanent injunction or perpetual injunction, and the second is temporary injunction. So when we talk about that order of injunction is in the nature of prohibitory order, not to do something, in a sense it is of two types. One is permanent, that is perpetual, and secondly is temporary, or what we call interim injunction. In case of temporary injunction, there may be one more aspect, and that is ad-interim injunction. Now we'll have to see the concept of each other in that case, which I will try to cover in the entire lecture, whatever time. I really beg pardon of all these particular students and the particular recipient, because I came late, because I started a little bit, but because of the traffic I could not come. What the chairman has taught me that this is the particular topic, so therefore you better start at 10 o'clock before lunch if it is to be completed. But still, sorry my friends, because of some unavoidable reasons this has happened. Coming back to the point, my friends. So therefore, when we talk about that, in a case of prohibitory order, permanent injunction and temporary injunction, the permanent injunction is governed by which provisions of law, my friends? Specific Relief Act. And permanent injunction is governed by the provisions of the Specific Relief Act, whereas temporary injunction is governed by the Civil Procedure Code. The permanent injunction is always, in that case, this always in the nature of a decree. That is a final order. If we see the provisions of section 37(2) of the Specific Relief Act, it defines that perpetual injunction always at the end of the trial. That is, after considering the entire trial, in short, the court decides the rights between the parties, even according to the permanent injunction. We see so many types, which I just now pointed out. Suit for partition, court decides the right. Whether a plaintiff has the right to get the property, get the share of the property, etc. Court decides the right. Similarly, in case of permanent injunction, court decides the right, that is, it is granted after the entire trial is over. Till that, court will never grant it. Perpetual injunction in the world. Now, what is the connection of perpetual and temporary injunction is very close, which I will explain to you by certain examples. In that case, we will try to consider that particular aspect. So therefore, perpetual injunction always at the end of the trial by way of a decree only, not otherwise. Temporary injunction duration is only during the pendency of the suit. The temporary injunction can be granted only during the pendency of the suit. So what is the object of the temporary injunction? The object is to maintain or to preserve the property as it is, as we call a status quo. Not order of the status quo I am pointing about, to maintain the status quo between the parties. For example, if the plaintiff comes in the court of law and he has a particular say that yes, the property is an ancestral property, or even if self-acquired property and father died intestate, as a result, she has got a 1/4 or whatever, may be 1/5 undivided share in the property. So therefore, when he comes before the court and ultimately files a suit, he will be asking a permanent injunction restraining the defendant from alienating the property, creating the third party interest in the property, or changing the nature of the property. That means nobody should carry out the construction, should not change the nature of the property. But you know that a permanent injunction can be granted only after a trial is concerned. And if the plaintiff has come in the court of law, and if he has to wait till 3 years, 4 years, 5 years, one doesn't know when the suit will be ultimately concluded, then during the pendency of the suit, subject matter is to be kept intact. What is the subject matter? plaintiff comes with the case, that is what we talk a fact and issue, as defined in Section 3 of the Indian Evidence Act. What is the fact and issue? A fact itself, together with other facts, whenever a right has been alleged and denied, and then in the basis of that, a right or liability would follow. That is what we always talk, a fact and issue, as defined in the Indian Evidence Act. So therefore, in that process, what is the fact and issue? Whether the plaintiff has got right, that is 1/4 here, and whether he is entitled to a separate or equitable partition. Now, if prima facie it appears, when we will consider what are the criteria of temporary injunction, if it is appear that, well, yes, it appears that the plaintiff has a triable case, then his right is required to be protected. Otherwise, if during the pendency of the suit, if no orders are passed, what will be the position? If the property is alienated, sold, etc., and ultimately court comes to a conclusion that the plaintiff has a right, plaintiff is entitled for injunction, if that particular case, then nothing will remain. That is what we say, to preserve the property, to keep the rights of the plaintiff and as well as the defendant in particular intact during the pendency of the suit, the temporary injunction is granted. This is the object of the temporary injunction. In short, temporary injunction will come to an end at the end of the trial. And suppose court comes to a conclusion in favor of the plaintiff that permanent injunction is liable to be granted or plaintiff is entitled, the temporary injunction will merge in the permanent injunction. In normal course, if this suit is dismissed, the temporary injunction will come to an end. Permanent injunction is always based on merits. That is when we are after trial. All the facts, all the law after considering. Temporary injunction, no doubt, is also considered on merits. But when I will tell you the merits of the so far as the temporary injunction is concerned, so that means that, well, what the court has to see that, well, a plaintiff has a triable case. Not necessarily that the court should consider at the time of temporary injunction that the plaintiff will succeed or plaintiff would not succeed. One of the criteria is no doubt that way, but not hard and fast rule to that effect when we will consider regarding certain aspects of the temporary injunction, my friends. So friends, therefore, in the light of this, therefore, we saw a perpetual injunction, then temporary injunction in that full case. That is what the interim injunction. Whereas mandatory injunction, my friends, and then we'll consider one by one. Mandatory injunction is also generally granted at the end of the trial. Because if the mandatory injunction, for example, I gave the example, tenant comes in the court of law and says that, well, my roof has been removed illegally. Therefore, direct the defendant to erect the roof with immediate effect. What remains in the suit? What remains in the suit? Nothing. Practically, granting a mandatory injunction at the temporary stage would amount to decision of the suit. And therefore, mandatory injunction is granted generally at the end of the trial. Of course, that does not mean court has no power to grant a mandatory temporary injunction. Court has got a power, but just like we say, a capital punishment in rarest of rarest cases. Bachan Singh, you know that well. So therefore, the rarest of rarest cases, but court has got power. When I will consider that aspect, I will tell you that well. So therefore, in a case of mandatory injunction, is also generally granted at the end of the trial by way of a decree. But court has got power in a given case, even to grant mandatory temporary injunction. If the court finds that, well, this is the mischief which the defendant has done, court will not hesitate to direct the defendant, Mr. Defendant, construct a wall even today. Even he says that amounts to granting a final relief, court will say nothing doing. So therefore, you can show that well, And in that particular, just like you know that the the Hindi films, etc., pet dialogue, law ke haath bahut lambe hote hai. The court has got a power even to grant that relief also. So therefore, you will find, my friends, that well, these are the conditions. Now, what is mean by ad-interim injunction? And let us consider then one by one its scope and then other aspects. We saw prohibitory and mandatory main two. In prohibitory and mandatory, perpetual, permanent, temporary, in case of mandatory also, perpetual, temporary. Then what is this concept of an ad interim injunction? Which I will explain to you. It depends upon, that is sometimes it is called as ex parte injunction. When we will see the provisions, the court generally does not grant ex parte injunction unless the other side is heard. But if the court at a given stage of particular suit comes to a conclusion that, well, the very ends of justice are going to be defeated, the court has got power to grant an ex parte injunction, that is without hearing the defendant, for a particular period, no doubt, till he appears, till he files reply, etc. But still the court has got power to grant injunction. Now that injunction, in application for temporary injunction, therefore it is called as ad interim injunction. Ad interim injunction lasts till temporary injunction. Suppose temporary injunction is rejected, ad interim injunction will automatically come to an end. And if the court comes to a conclusion that yes, plaintiff is entitled for a temporary injunction, ad interim injunction, if granted, will merge in that well. Now, ad interim injunction is not always granted. In some cases it is granted, some cases may not be granted. But that concept also a lawyer must know. And that is what we talk about, the ad interim injunction. Now, my friends, let us consider now one by one. When we talk about the prohibitory injunction, that is the particular not to do something, we'll first see the prohibitory injunction. That is the prohibitory order. And in this prohibitory order, we'll first consider in that case the permanent injunction or perpetual injunction. And that is governed by, my friends, Section 38 of the Specific Relief Act. Section 38 of the Specific, that means power or the source to grant a permanent injunction is only Specific Relief Act. Now in that particular case, a permanent injunction can be granted by the court, which I already told you at the end of the trial or by way of a decree. Let us see the particular concept in that case and let us go that way, in which cases permanent injunction can be granted and in which cases permanent injunction cannot be granted. That aspect need to be taken into consideration. Now friends, as regards the permanent injunction when we talk about, the first thing which Section 38 contemplates that well, if the plaintiff satisfy to the court that there is an obligation in his favor. The word that has been used is that well, obligation in favor of the plaintiff. Then only the injunction, permanent injunction can be granted. What is this concept of an obligation? The word obligation has been defined in Section 2 into bracket A of the Specific Relief Act. An obligation means every duty cast upon the defendant which is enforceable according to the law. So there must be some duty. Why I am pointing out, friends, when we will be drafting a plaint, today that is not the subject. For last 3-4 years when I was coming here, the subject always was given to me that well, this pleading and notice. This time chairman asked me, I say, let us have some change. And therefore I asked that well, he said that well, sir, the people require that well, students require, lawyers require every day regarding injunction. Will you take this one? I will take it accordingly so. So therefore when you are drafting the plaint, this starts with, my friends, we are required to make out a case. Therefore, permanent injunction can be granted. This is one of the facet obligation. When we are going to consider 4 or 5 aspects which have been embodied in Section 38 of the Specific Relief Act, will take into consideration that. The first is that well, plaintiff comes with the case and or can come with the case that there is an obligation in his favor. And if there is an obligation in his favor, then the court can grant a permanent injunction. Remember my this friend, because when I will tell you, criteria for grant of temporary injunction is again connected with the permanent injunction. And how, I will explain to you. Ultimately one can argue that if party prima facie is not entitled, that is plaintiff not prima facie entitled for permanent injunction, he is not entitled for temporary injunction. Apart from that, the phraseology used in Order 39 Rule 1 and 2. Apart from the fact prima facie case, etc., etc., etc. These are another concept. But still, the basis for grant of temporary injunction is again whether prima facie court finds that whether he would be entitled. That means if ultimately final relief cannot be granted, because permanent injunction can be granted by of only final relief, by of a decree. And if on the face of it, if the plaintiff is not entitled for a permanent injunction, then court may not grant a temporary injunction. Of course, we are going to consider it separately, but I will tell you. But I will explain to you while considering the permanent injunction what is mean by where final relief cannot be granted, in which cases it can be granted, in which cases it cannot be granted. Now friends, therefore I was telling you obligation. Now this obligation may be several types. First obligation, can anybody point out? First type of obligation we always talk about. Contractual obligation. Obligation is created, you know what is the concept of the contract? Contract is a freedom of right. When the two parties come together, they have got a fullest freedom to discuss about the terms and conditions. And by using that total freedom, they agree to do something. Therefore, law says that, well, if you have agreed to do something, that is your contractual obligation. And if that is a contractual obligation, you must perform it. And if you must perform it, court will not hesitate to grant a permanent injunction. That is the concept of, my friend, obligation. Therefore, wording is obligation as defined. Every duty which is enforceable according to the law. So therefore, the first duty may arise out of contractual obligation. There may be another duty, may be arising out of statutory duty. According to the statute, certain provisions of the statute. I will give you an example and then you will understand it, or you will be able to appreciate it. If a simple example, A agrees to sell the property to B, it's only an agreement to sell. Whether agreement to sell create any right in favor of the defendant? No. Section 54 of the Transfer of Property Act clearly says it would not create any